Thank you, Mayor. And thank you to everyone who showed up tonight. It's clear that this is an issue that is very important to a lot of people. I would like to share from a city perspective that since the swearing in of the district attorney, Alonzo Payne, on January 12th, 2021, staff has become increasingly concerned about several areas: the professionalism of the office, the potential violations of the Victim Rights Act, also known as VRA, the unprecedented use of sweetheart plea deals for serious crimes, the lack of response in carrying out regular duties and communicating as a partner, and then the risk this places on our law enforcement officers because of emboldened criminals. As staff, we've made every effort to meet with the district attorney in an attempt to share these concerns and hopefully correct them, but those efforts have been fruitless. The district attorney has made it abundantly clear that the philosophical platform that he ran on applies to all levels of crimes, and that he does not believe jail is productive. He has also made it very clear to us that he does not take the city's concerns very seriously, and he has no intention of changing. That's what has led us to tonight. When the chief and I met with DA Payne, I shared that at the city of Alamosa, we share some of those philosophical beliefs. The city has had a youth diversion program for almost 10 years, and we have an adult diversion program. We've started the LEAD program that's been expanded to many areas in the Valley, and we're getting ready to start the co-responder program. As City Council, you have decriminalized a majority of the municipal violations and removed jail as an option. We have made it clear throughout the years that we believe for lower level offenses, such as those that are prosecuted through municipal court or those that have an underlying addiction and/or mental health component, that jail may not be the most appropriate tool. Where we differ with the district attorney is that we believe on the higher level offenses, jail might be the correct tool, especially when there's a significant threat to the public, such as murder, sexual assault, domestic abuse, or drug distribution. I want to share this information about what the city's stance and philosophy has been, because I want to make it 100% clear that this is not about being a Democrat or a Republican. I do not want someone to discredit what our concerns are and try to say that we're simply against this Democrat with his political platform. The item tonight before council honestly is unprecedented. And I'm going to admit right now, I know we used strong language in both our presentation and the written materials. We're not throwing these words like incompetence around lightly. We do know we are talking about someone who was elected by residents. But as we began to look at this issue, it was like lifting a rock and a lot of ugly things started crawling out. Listening to the victims, which you've just gotten a small taste of tonight, is utterly heartbreaking. Listening to the professionals across the state as they sit on these boards and listen to this information and have to grapple with the utter disregard for the law, the authority of the state, and the disdain towards victims, it is embarrassing.
City Council, Mr. Mayor, I want to share with you a few samples of plea deals that highlight the threat, excuse me, that highlight the threat to our community. Our police department has conducted over 40 narcotic operations in the last 9 months. Not one of these cases has resulted in a trial. They have all been dismissed or pled to less serious offenses with very minimal jail time. These operations include significant amounts of seized drugs, money, and weapons. Heather's got the pictures up, so go ahead and go through these. We've got a few pictures, just obviously things that we get on all of these narcotic operations. A lot of drugs, money, that's about close to half a pound of heroin right there. Same thing there, crystal meth, go ahead and go down. One of the things we're running into quite frequently on these narcotic operations are these. Hold it there, hold it there. This is semi-automatic 12 gauge. Semi-automatic 12 gauge, okay? Gets better. Go to the next one, please. So I wanted to show this picture because these weapons that we're running into now, I'm kind of considering them to be cop killers. These will penetrate our bulletproof vests. That right there is a AR-10. Okay, a lot of you have heard what an AR-15 is. Well, this is an AR-10. It shoots a 308 caliber round. It's the same round I use going elk hunting. Okay, dangerous weapons held by very dangerous people. Okay, thank you. In comparison, when the city partnered with federal agencies on some of these cases, hold on one sec. We partnered with federal agencies on a few of these cases. I just wanted to kind of give you guys an idea of what the outcomes were in federal court compared to what they are in our state court. 3 cases, 10 years, 15 years, 15 years. That's Fed prison time. Well deserved too. Let me give you an example on a couple of these cases. Mr. Eric Gibbs, charge of murder, pled down to criminal attempt, tampering with a deceased body. Due to the plea being a non-violent felony, Mr. Gibbs has the possibility to be eligible for parole after 3 years. Mr. Gibbs allegedly shot and killed a person in his home, buried the body underneath his house, and booby-trapped the house with explosives. An entire city block had to be evacuated while waiting for the Pueblo bomb squad to secure the scene. I was at this one. Mr. Richard Newton, officers made contact in a parking lot in Alamosa in the city limits for an active arrest warrant. Mr. Newton refused to exit his vehicle and accelerated, dragging a Colorado State Patrol trooper who was backing up one of my city officers through the parking lot, causing injury to the officer. We are very lucky that this was not more serious and that officer was not injured more than he was. However, Mr. Newton was charged with assault 1 serious bodily injury with a deadly weapon. That's an F3 felony, punishable by 10 to 30 years in prison, resisting arrest, obstructing government operations, reckless endangerment, and reckless driving. The case was pled to assault 2, an F2, a felony punishable by 5 to 16 years. But under the plea deal that our district attorney provided, he received a deferred sentence for 36 months and 60 hours of community service. All other charges were dismissed. Trey Howell and April Behrens, another case, murder of a 16-month-old baby who had trauma to the brain due to being smashed into a door. Howell pled to accessory to crime and got 72 months deferred sentence with terms and conditions of probation. It's unacceptable. Behrens pled to child abuse negligently causing serious bodily injury attempt and received 2 years community corrections with 369 days time served, credit for time served.
As we talk about the district attorney, and from what you've heard tonight, clearly we need to talk about the violations of the VRA. As of February 9th, the Colorado Crime Victim Advisory Board has received 8 complaints under the VRA. For the first time since the existence of this board, which is approximately 30 years, the board found that the DA's office was non-compliant in regards to 4 of the complaints and voted to refer the matter to the governor's office. The other 4 complaints that came in later were reviewed on February 25th. The subcommittee at that point in time unanimously found that all the allegations of violations of the VRA in these last 4 complaints were substantiated and forwarded them to the Colorado Crime Victim Advisory Board. Of note, normally this subcommittee would try to rectify the situation with the district attorney's office, but given the 4 prior complaints, they figured that would be pointless and instead voted to send it immediately to the board, which they anticipate will be forwarded to the governor and ultimately the AG as well. As the city attorney listened in on the meeting, there were several comments that were made that actually sound very similar to those comments shared with you tonight. It's a dereliction of duty, victim blaming, appalling and egregious, re-victimized by the person who is supposed to be advocating for you. The victim felt the DA was working on behalf of the defendant and not the victim. We don't have a background in these complaints to the VRA. So we have no idea if 8 is a lot. So we sent in a request for information and found out for the previous 4 years prior to Alonzo Payne, there were 0 complaints issued to this board. The complaints include lack of fairness, respect, or dignity, lack of information related to the plea deals and hearings, requests for information just being simply ignored, refusing to meet with the victims, and explosive and confrontational behavior. As the Colorado Division of Criminal Justice tried to work through these complaints, they made multiple attempts to contact the district attorney. Email, mail, certified mail. All of those were ignored by the district attorney's office. As I listened in to a separate meeting for the first 4 complaints, there were a lot of comments that caught my attention. One of the reviewers with over 10 years of experience noted that it was the most egregious complaint ever reviewed by the board. When describing the environment that the trainers encountered when they were on site at District Attorney Payne's office for the VRA mandatory training, 2 staff members were dressed inappropriately, one in sweats and another in a superhero shorts and a t-shirt. One attendee would have an outburst almost every 40 minutes, causing the training to have to pause. Even though the training was required and scheduled in advance, the district attorney missed over an hour, and when he was present, spent a significant amount of time on his phone, disengaged from the training. The trainers indicated that it was the most hostile and unhealthy environment they had ever encountered. There was a clear lack of respect and professionalism. About a month following this mandatory training, the board was made aware that there were another 20 cases that were either dismissed or pled out without contact with the victims, a clear indication that the training was not taken seriously.
In addition to these areas, we've also found the office to be non-responsive to communication efforts, dismissive and combative during meetings, and lacking in timely performance of duties. For example, in December, it was brought to my attention that over 20 warrants within my police department had not been processed, which means 20 different cases with victims had sat on the DA's desk without actions for weeks and some longer. These included domestic violence cases, third-degree assault, second-degree assault, second-degree forgery, theft, second-degrry burglary, and felony menacing cases. Such a delay can have serious consequences. I want you to bear with me for a sec. I am not a robot, okay? Just want you to be aware. OMS student Jaden Cruz. He'd been bullied at school, and on Friday, October 1st of 2021, I apologize, guys. I'm doing the best I can here.
Take your time, Chief. Take your time. We got you. You're good. Take your time. Take your time.
Okay, so Jaden been bullied at school Friday, October 1st, 2021. He was assaulted by other students, as other individuals have mentioned today. Our department had the charges to the district attorney the following Monday. This occurred Friday. We got the charges there Monday. The charges sat without action on the DA's desk. On December 21st of 2021, Jaden tragically took his own life. Get in there, get in there. I want you to think about the dates here. Yeah, thanks. I got it. Okay. Sorry, guys. The DA's office finally filed the charges on January 11th of 2022. You all heard the dates that I read to you, correct? This is a 13-year-old kid. His guardians assert that without the abandonment by the district attorney's office, Jaden more than likely would not have killed himself. Go ahead, Heather.
What we want to point out tonight as well is that the excuses and the narrative that the district attorney provides, they're not relative, and they do not explain away the actions or lack of actions from his office. The district attorney will say his office is underfunded or that he has a big workload to keep up with. But for the last decade, the district attorney's office has been underfunded. That has been true for every single district attorney who's held the office prior to District Attorney Payne. Yet these previous district attorneys have prosecuted high-level offenses and sought jail time. Also, as a side note, I do want to mention during this time that we've heard that there might be pressure on the county commissioners to reduce funding for the district attorney's office. From a staff perspective, we want to be clear that given the historical lack of funding for the DA's office, we don't believe reducing funding will help. It will only further weaken any prosecution, and it's not going to change the motive for District Attorney Payne or motivate him. In fact, with less money, the district attorney will only have another excuse for why he cannot aggressively prosecute. So we don't feel it is a good long-term strategy. The district attorney has also indicated that staff changes, mostly the departure of Deputy DA Alex Rains, should address the concerns related to the VRA violations. However, these violations have been occurring for over a year. They have involved more than just one attorney, including the district attorney himself, and it speaks directly to his leadership in his office. I also anticipate that the district attorney will attempt to claim that the dissatisfaction that us and those in the public have is based on the political differences, i.e. a Democrat versus Republican. To that, I want to point out something that's obvious. We have a city council that's diverse and represents both political parties and even independents. As I've talked to community partners about these concerns, the dissatisfaction crosses both political parties. And finally, that's why we opened this presentation with the history of the city and the philosophy we have on the lower level crimes.
Through DA Payne's efforts to avoid jail sentences, there's been an increase in the use of the 12th Judicial District Probation Office for more serious offenses. I wanted to learn more, so I met with Bill Gurley. He's the Chief Probation Officer within the 12th, and he's here tonight. Currently, his office has 14 certified probation officers. These probation officers are responsible for over 700 probation clients to date. It's about 50 clients per officer. None of the certified probation officers carry a sidearm or a bulletproof vest. As of lately, the new clients being referred to the probation officer are too high risk, and it is dangerous for the probation officers who are not equipped, thus putting the lives of the officers more at risk. One might ask, if they are too dangerous for probation officers, why are the cases being pled down and jail not being utilized? I think that's where we need to start using jail.
When we first began looking into this situation, one of the first questions we had is, what is the role of the judges? In fact, District Attorney Payne has also tried to dodge his accountability by indicating that the plea deals and dismissals are okay because the judges have allowed them. What I have learned is that it's more complicated than this. There is a general discomfort among some judges about the plea deals, dismissals, and veracity of the district attorney's word when it comes to working with victims. For a dismissal, all that the prosecutor has to show is a legal reason for the dismissal, which often can be that they cannot prove the case beyond a reasonable doubt, or that the victim will not cooperate. Since the judges do not have access to the evidence, nor are they privy to the communication of victims, they have to rely on the word the word of the prosecutor. It is also similar for plea deals and bond hearings. There have been a few instances where judges have denied a plea deal and/or dismissal. In one instance, when a judge was hesitant to accept a plea, the prosecutor made a comment that they would just dismiss the case then, thus resulting in no penalties. I've also learned that there may have been multiple instances where the district attorney's office has told the court that they have communicated with the victim when in fact the victims claim otherwise. To get to this point, we plan to submit a CORA request to identify these instances because that would constitute a very serious ethical violation.
In District Attorney Payne's own words, overzealous and unwarranted prosecutions have put such a strain on our criminal justice system that it is at a breaking point. I would argue that applying the oversimplified don't put them in jail philosophy to all levels of crime is simply irresponsible and contrary to the role of the prosecutor. There's a difference between someone who is shoplifting because of an underlying substance use condition and someone who is distributing pounds of drugs with assault weapons and thousands of dollars in drug money. There's a difference between low-level offenses and murder. The inappropriate plea deals have left victims feeling helpless and often re-victimized and have sent a clear message to those considering great law consequences or accountability for criminal activity put our community and officers at risk. We put our officers' lives at risk every time they have to make an entry on a narcotics operation or any other critical incident. Our neighborhoods and residents are at risk when criminals are allowed to avoid jail time and walk around our community. I am the one they call when they are scared, and I'll be honest, I am running out of responses. The comments I hear now from residents, at least we have a day of no fear. That's why we're arresting them and taking them to jail, because they know they'll be out tomorrow. These are our victims whose voices are being ignored. Victims I made a pledge to protect and serve over 21 years ago, and I stand firm on that.
So this is a tough situation for the city because we actually have no control over the district attorney, who is an elected official. However, there is a current movement to petition for a recall election, and that is what brings us to tonight. Under the city code section 5-42, council can direct the city to spend up to $10,000 on ballot issues in local elections. However, as it's currently written, we cannot spend that on candidates or recall of persons holding office. We made this distinction when writing the ordinance because we wanted to prevent spending on specific candidates for state or local office. However, the current circumstances show us that that may have been short-sighted when it comes to incompetence or the application of misguided policy when someone may need to be recalled. There is a direct city interest as it does have an impact on the city's financial and operational condition. Ordinance 5-22 would allow the city to spend funds on recall efforts for non-city recall elections. Since this would be a recall that covers the entire valley and is not just a local, we would only be able to spend funding up to the point where the Secretary of State certifies that the number of signatures, approximately 4,000, is sufficient to meet the standard. After that, we would not be able to participate. The expenditures, as we've written this ordinance, would be limited to recall elections where we can show a direct city interest. I recommend approving ordinance 5-2022 that is before you tonight, that would allow you to consider a resolution at your next meeting on March 16th. Additionally to approving these changes, I recommend submitting a letter to the Attorney General's office requesting an expanded investigation beyond just the VRA complaints. We also recommend that you authorize us to investigate whether any of District Attorney Payne's actions relating to the cases he reviews and representations to the court concerning facts surrounding those cases violate his ethical obligations under the Colorado Rules of Professional Conduct. Given the overwhelming breakdown of the judicial process because of poor performance, poor management, and the extreme application of a philosophy, staff does not feel that our community will be safe under the leadership of DA Payne, and that another 3 years is not sustainable. Thank you, Mayor.
Thank you. Thank you very much.